Welcome to Legal Straight Talk. I'm Brett Harrison from the Harrison Law Group. And again, we're fortunate to have Betty Tufariello come back to talk about patents, trademarks, or intellectual property. Betty, I want to go back to patent and trademarks.
Sure.
You know, last we left off, we were in a big glass room as the patent or trademark office, with papers up to the ceiling. Now I guess it's all computerized, I would assume.
Yeah.
Okay. And we're thinking of these either old woman or old man sitting behind the desk saying, stamp, no good, good, need more information.
Yes.
Is that what happens?
Actually, yes, it does. That's exactly
okay.
how it happens. And actually, very recently when I was at the patent office in Washington, D.C., in fact, there is somebody in a little cubicle 8 by 10 with files all the way up to the ceiling trying to wade his way through the patent applications. So the answer is yes. Somebody does make a decision whether they're going to grant the patent or whether they're going to issue a trademark registration or whether the copyright met all the requirements to get a certificate of registration.
What are the basic requirements?
Well, let's talk a little bit about trademarks. Let's start there because we spent a lot of time on trademarks. A trademark basically has to fall into a particular category in order for it to merit protection. Okay? And to merit protection in the form of a registration. The United States Supreme Court has identified basically 4 categories of trademarks: inherently distinctive, suggestive, descriptive, and generic. If the trademark...
Sounds like some of the women I've dated. I can categorize them
Yeah, I've thought
way.
about that too.
Or the men you've dated.
Or the men I've dated. So,
Okay.
so basically what happens is if your trademark falls into, let's say, the category of being deemed generic, then you're not getting a registration to save your life.
What's an example of that?
I will in a moment.
Okay, go through the 4.
Let me go through the 4, and because once I go through the 4, you'll understand
Okay.
that there's a method to my madness. Descriptive trademarks are merit protection only if they have acquired secondary meaning. If they have not acquired secondary meaning, then they get a registration, but it's one of those things that I call a quasi-registration, and I'll explain that in a minute. Suggestive or inherently descriptive trademarks. Suggestive trademarks, inherently descriptive trademarks are trademarks that tell you absolutely nothing about the products or the goods and services in connection with which they're being used. And they merit protection right from the get-go.
Okay.
So, famous inherently distinctive trademarks. And what is an inherently distinctive trademark? It's one that tells you absolutely nothing about the goods or services in connection with which it's being used. Nothing. So, a good one, Xerox. The only reason you know what Xerox is because of all the marketing. The name itself, Xerox, tells you nothing about the goods in connection with which it's being used.
So it's more trademarking the name.
Yes. We're talking about...
People recognize or associate Xerox some way, so that's why that's trademarkable. Is that what you're saying?
No.
Okay.
An inherently distinctive trademark is a trademark that tells you absolutely nothing about the goods or services in connection with which it's being used. It doesn't tell you whether it's made out of ice cream or it's made out of wood. It doesn't tell you whether it's a tire or whether it's a piece of bread. It doesn't tell you whether it is used...
So where's the value? Just in somebody else using the name or concept of Xerox?
The value is the fact that it's so unique and inherently distinctive that once it goes out into the market and people get to know it, they will never confuse it as coming from Nike.
Okay.
Okay? That's what inherently distinctive means. It means that once people get to know it, and get to know it as a result of marketing and advertising and promotion and sales in the industry, they know that a Xerox product comes from Xerox and it doesn't mean a copier. Okay? Suggestive is a trademark, a suggestive trademark, is a trademark where people have to engage in a series of steps in their thinking process before they figure out a property or quality of the goods in connection with which it's being used.
Give me an example.
White cloud for toilet paper.
Okay.
Think about it. White cloud, toilet paper. Most of us believe that clouds, little white clouds, are soft and cuddly and comfortable and
Okay.
a real pleasure to rub them on our skin. We take white cloud, we put it on toilet paper, it immediately suggests a particular quality of the product in connection with which it's being used. That's a suggestive trademark.
Oh,
Okay? So, suggestive trademarks and inherently distinctive trademarks get registrations almost immediately.
Okay.
You take the applications.
But I'm sure there's steps that you have to show, or certain, what we call litmus tests. That
No.
Really? There's
No.
not 4 or 5 things that, when you have a client that says, I want to do this, you kind of have a,
The only thing I do is do a trademark search.
okay, we're going to get into that because I'm interested in somebody that wants to do a trademark or a patent search
Mm-hmm.
before they submit it, which would be the smart thing to do, and before
Yes.
they invest all this time, money, and energy.
Yes.
But let's do the other two.
Okay. So that's the only thing that I would recommend before we file a trademark application. Because once I've done my trademark search and I'm satisfied that it's inherently distinctive or suggestive, and I know exactly what my goods and
Okay.
services are going to be used and where my company is, I file the application. It goes through a preliminary examination by an examiner at the trademark office. If there's some
A guy or woman in a different cubicle.
Yeah, exactly, because you have the trademark office on this side, the patent office on that side. And
Never
it-
the two shall meet.
No, and they don't. Usually you can get a trademark registration anywhere from about a year
Oh.
to about 3 years, depending on where
But you
you
want
are
to make
in
sure
it.
you have it stamped, am I correct? Or the
It
pay
gets
the fee?
stamped. The way
So,
you file it,
time
yeah, it's
and date.
oh yes, you want to, it's, filing is very important. You
That's-
need to start filing as soon as you make a
But
decision.
how do you do a search? Describe what a
The
search.
trademark search.
Trademarks, what does it generally cost? What are the steps? I mean,
Generally speaking, trademark searches, when you do a search on the internet and you go to some of these websites, Trademark is a very good one, LegalZoom now sells trademark searches, it gives you the impression that you can do a trademark search a la carte. We'll do a trademark search in the federal trademark office, and if it's okay, we'll go ahead and file. That's not how we do trademark searches. My firm litigates, and because we litigate, we know what the pitfalls can be. And so when we do trademark searches, we do them super in-depth. We actually do federal, state, international, common law, and what I like to say, corporate.
so
And-
there's a big difference between U.S., European trademark, or Asian, I mean, there's all these other
In terms of what?
I mean, just because you search in the U.S. doesn't mean it's not trademarked in another country.
That is correct. And actually, you should be doing international because
Is it just one international, or is it broken down
It's
into
broken down.
regions from Asian
it's broken down.
trademark to?
Trademarks are territorial. They are territorial. Every country has its own trademark system. Lucky for us, we have now the Madrid Protocol, which is an international treaty that governs international trademarks or
But
trademarks.
not every
that-
country is involved in that.
No, but most of them are. There's last time I checked, there were over 178 countries signed up.
Including China.
Including China. China is actually a signatory of the Madrid Protocol. Believe it or not, Canada is not.
Why?
I don't know. I still haven't figured it out. So I actually
I
have
would
to do
think-
a separate trademark search in Canada. But you really want to do
And how
international
long do
trademark
those
search.
take to get back?
The trademark searches, we do them in-house and we usually turn them around in 10 days.
Whether even international ones,
Yes,
wherever it is?
yes,
And
yes.
now, what's the cost to do it? I mean, that's an open-ended question, but.
Without giving my own trade secrets away.
But, what's we'll call it standard industry, what's the general range? And obviously, it's gonna depend. I
It
guess,
really
on the
depends.
fact-
It really depends on the individual trademark searches. It also depends on whether letters of opinion are issued. What good is doing a trademark search, getting results, and then looking at them and not knowing whether they're appropriate or not? Somebody has to read those
Now,
search results.
doing these searches as you do, whether it just be U.S. And internationally and Canada.
Yeah, we do
and
them
all
across
of
the board.
Across the board, does that show for down the road, potentially a good faith effort was substantially made that you're utilizing in case litigation comes up down the road?
You're absolutely correct.
Okay.
Absolutely correct. See, damages in a trademark case are only assessed against you if you adopted the trademark in bad faith. Tommy Hilfiger got smacked hundreds of millions of dollars because his lawyers told him to do a trademark search, and he did not. And as a result, both he and Kmart got dragged into federal court and got sued for trademark infringement. Now, Kmart got off because they were simply the retailer to whom Tommy Hilfiger was applying the goods. But Tommy Hilfiger, because he did not do a trademark search, the court comes back and says, you, Mr. Hilfiger, and I'm using that, obviously, I doubted that Mr. Hilfiger was actually sitting there in the chair, but basically the judge said, you, Mr. Hilfiger, that you have built your company on trademarks, that you know the value of a trademark. For you to intentionally, to abandon the trademark search that your lawyers recommended, your failure to do that.
I'm guessing his lawyers put that in writing to him.
I'm not sure.
Because he's going to say he didn't know.
I'm pretty sure they did. But the bottom line is he should have. And because he did not, he paid a lot of damages.
Are the damages subjective to what the judge, or is there certain...
There's a formula.
Okay.
There's a formula in the statute that says you can get, you plaintiff, if you're the plaintiff and you're suing, you plaintiff, you can get your lost sales, plus you can get defendants' profits if they're not duplicative of your lost sales, okay? Plus you can get your attorney's fees and costs, and you can get them trebled if you can show bad faith.
Or can they decide, the other side, to say, you know what, we'll let you use it, but we want 25%.
Oh, of course. That possibility of a license during the litigation is at any time.
So it still may behoove the person to forego that search if they feel that they may only have to give up 25% of the profits. I mean, that's a calculated risk.
It's a very calculated risk. Right. It's a very calculated risk, and sometimes it pays off and sometimes it does not. Especially in the shoe industry, because the shoe industry is actually quite prolific of the fashion industry in general. Everybody copies everybody else, and sometimes they avoid doing trademark searches or patent searches or design patent searches.
Sometimes, if it's a hot commodity and it's a hot item, if you do the trademark, by the time you get approved or not approved, the timing of it's off.
No, that might be true in the case of a patent, but not in the case of a trademark. Remember,
I'm thinking of from the fashion world.
Even in the case of a trademark, even if I'm Eddie Bauer, right, and names, for example, are considered descriptive. They're not considered. Actually, I'm using that word loosely because we didn't talk about descriptive and generic. We only talked about inherently distinctive and suggestive.
So let's talk about descriptive.
So let's talk about descriptive. Okay. So descriptive trademarks are exactly that. Trademarks that tell you something about the goods or services in connection with which they're being used.
Like?
Vitamin water. Now, I specifically use vitamin water because I was actually the attorney who managed to secure the registrations for those trademarks.
Oh, wow.
And look at them now. They're fantastic.
Look at all the stars. 50 Cent made more money on that.
I guess so.
And some of the stars that invested in that or became one of the names behind it.
At the time they had not, but when I was filing the application, but I assure you I was sleeping on those files while they were going through the trademark office, because my client did call me numerous times in the middle of the night to ask the status of the applications.
Do they have an expedited fee too that you can pay? Not that it means
not in trademarks per se, but in patents, yes. In patents we do have expedited filings. And just recently we were successful in securing a patent for a fantastic detector for methane gas.
Oh, wow.
And we were able to pull it through in 9 months, which is unheard of. The fees, of course, are elevated, much, much more elevated than a regular, because what you're in essence doing is you're taking it out of turn, because it's a first-come, first-served basis. Right. You're taking it out of turn, and you're saying to the examiner, listen, I need you to pay attention to this file right here, and for your attention, I'm willing to pay the government $4,000 as opposed to $2,000 or $1,000
But I would
from
assume most people would pay the expedited fee.
No. Most people don't. It's very unusual for companies to decide to do it, unless they have a lot of money. In this case, it was very important for us to get the patent, only because there was a potential license that was going to fall through if we didn't have the patent.
Okay.
So there were legitimate business reasons.
Now, when you file for an expedited, Do you tell them why it's important that it should be expedited?
Nope. You just say, I want it expedited.
Oh, you don't? Okay.
Here's the money. There are rules that you have to follow for the
Forget
preparation.
about these 20,000 applications. Put mine first.
Exactly. If you're willing to pay the money and you meet the requirements that are literally laid out in the patent rules,
Right.
then you have no issue and your patent will be expedited and pushed through.
So now let's get to the last one.
Okay, so we talked about descriptive. I said vitamin water. Another one is preferred soy, right? So let's say you're lactose intolerant and you only eat products that have soy, and you're walking down the supermarket and you really want chocolate pudding, but you can't drink milk. So you go to the refrigerator section and you see preferred soy, and you see it on little, cups with chocolate pudding. That trademark immediately communicates to you that that particular product is made of soy milk. So you purchase it not because you know the company or you value the product that comes from that company. You purchase it because that trademark communicates something about the product. That's descriptive. Vitamin water, water with vitamins. Okay? Fruit water, water with fruit in it. Smart water. Well, smart water was a little different because that one was suggestive.
Yeah.
Okay? But the vitamin water in particular, it was definitely descriptive. Now, descriptive trademarks also can get registered, but they're not registered on the principal register because there are two registers in the trademark office. There's the principal register and the supplemental register. We've registered trademarks because we want to be able to enforce them nationwide. See, trademarks are not only territorial to the country, but in the United States, they're also territorial to the state.
Oh.
Did you know that every state of the union has its own trademark database?
Wow, I didn't know that.
So there are companies who, because they don't do business in Alaska or they don't do business in Texas, and the only place they do business is in Alabama, they will only file in the trademark office in Alabama.
So they're not protected here in New York?
No, they're not, but they are protected in Alabama. But here's something that most people need to think about. If you're planning on bringing your product or your service nationwide, and there is a company in Alabama that's using your trademark ahead of you, you will not be able to do business in Alabama. That company in Alabama will be able to stop you from using your trademark, even though you have a federal registration.
Unless they make a deal with you.
Yeah, and it happens all the time. But then you pay through the nose. Because they were there first. They were in Alabama. And if Alabama is a state you want to be in, you're in deep trouble. You're going to pay for that privilege with insane amounts of money.
Now, I want to switch it around a little bit. I want to talk about privacy.
Why?
Well, now, let's say we were talking a little bit off there again about if somebody takes a picture of me, you, or whomever, you can sue for privacy. What is that? Copyright for infringement, privacy.
It depends. It depends on how it's used. Definitely.
Like, for example, I remember seeing, was it Kardashian? I believe was suing people for utilizing her picture. People selling her picture. Or if the image was used somewhere else, automatically this attorney firm must have made a fortune.
They probably did.
Because I'm sure they sent that threatening letter that you talked about.
Cease and desist, yep.
The cease and desist, and if you don't, and they put the whole section of the codes and this and that. But how does that work? Talk about privacy and for-profit.
Kardashian, actually, the hypothetical of Kardashian is easy because Kardashian is very well known. And so if the Kardashian family wanted to sue, a particular entity for improperly or without authorization using their name or using their likeness in some way, they would be able to do it not only under the privacy rules or publicity rules of the state where the alleged offense is occurring, but they could also do it under 15 U.S.C. Section 1125A, which is unfair competition, federal unfair competition. As a matter of fact, two very famous cases.
What's the unfair competition mean?
It's basically, the statute says if you mislead the public and lead it to believe that there is an affiliation between you and the company or the entity or that picture, you're competing unfairly. You're using my likeness in a manner that I did not authorize.
So let's say I take a picture of who was the guy that used to spell all the loving? love novels.
No, I'll give you an...
Fabio? Is that Fabio?
I will give you an example, yes.
And they
yes.
put him
But
on
there
the
were
cover.
2 cases. There were 2
Oh, there are
cases.
cases. Okay,
there
why
were
don't you-
2 cases that used the likeness without authorization. James Brown
Okay.
and Vanna White.
They use, okay.
And Joan Rivers. Bud Light. The Bud Light commercials in the 90s. I don't know if you remember them, and now we're really dating ourselves
Okay.
by doing that. Okay. Bud Light commercial. There was a robot that would come out, come right up to the bar.
Right.
And then, he would say, give me a beer.
Yeah, right.
And the bartender would swing the Bud Light down, right? The robot would, he had hair on a toupee. All it looked like R2-D2, not R2-D2, C-3PO from Star Wars.
Okay.
Right? Remember so it kind of looked like that, and then it had a wig that looked like James Brown's hair. So you're kind of looking at it, and you're like, nah, it can't be James Brown, right? He takes a sip from the beer, and then he goes, ow, I feel good, and he zips around.
So now it's the likeness.
So it gave the impression to the world that James Brown had authorized his use, his likeness in the form of a robot, to sell Bud Light, and that he had approved a Bud Light. And damn, Bud Light makes you feel good.
And that's the confusion, right.
Exactly. And so people now go out and buy beer because they think James Brown approved of it or authorized.
But if they not only bought the beer, but now bought his CD.
Well, they didn't. They just bought the beer.
Okay.
James Brown, in fact, sued and won.
Wow.
Joan Rivers, the same thing. Same exact thing. You had a C-3PO come out, C-3PO with the characteristic hair of Joan Rivers. The beer, same exact scenario. They sued not only under the privacy and publicity rights of the state of California, but also under unfair competition.
So she had a better lawyer.
So now, let me give you the scenario of a person who nobody knows. He just has a very peculiar name. And he happens to be the only one who has that name. And somebody writes a book and calls his protagonist that name. Case or not?
I don't know.
Case, yes. I actually represented the individual.
Wow.
And we did sue, and we did win.
When you're suing in these cases,
And we did assert privacy rights, by the way, of the state of New York.
probably because there was better damage clause with that.
We,
Or just a number of your 25 theories.
Truthfully, we threw the kitchen sink up on
okay.
the wall and hoped
Sometimes-
like hell. But it was, in fact, something that should not have been done, because what was happening was this man's reputation, especially because the protagonist in the book was not a nice person. And so this gentleman's reputation was being affected very, very, very badly. He wound up losing clients. He was in a very prominent position. People were coming up to him and saying, "Hey, I read this book, and oh my God, you did what?"
Oh, wow.
So it was just not good. And so we were able to get him peace of mind.
Now, was the defendant trying to say, I just picked this name out of a hat, or didn't you have to, when you deposed that person, how did you come up with this name?
Thank God we never got there.
But how would you have, I'm just thinking now from a legal standpoint, if you're questioning me, your question would be, how did you come up with that name?
I really don't want to get into it, because I'm afraid that if I do, I may reveal more than I'm supposed to.
No, but I'm saying hypothetically, that would be a
no
difficult
question,
deposition.
No question at all.
I think you
would
have potential proof problems.
Yeah, in this case, we didn't. In this case, we were good on that level.
So you did your research on
Yes,
that.
in this
how
case,
that
we were
person
good.
got to that
Yes.
name, how the
Yes.
association, how you
Yes.
can show there was an association, so that's the only way he could have gotten, or she could have gotten
That
that
was
name.
one of the things that we were looking at. Right?
Because
and
I
I'm
would
being very close-mouthed right now, because
Because I
I do have
imagine-
a confidentiality
I
agreement
imagine a
in
summary
place.
judgment motion was initially made by the other
We never
side.
even got there.
I'm surprised.
We never got there.
I guess you showed them enough.
Yes, that's correct.
Okay, we'll leave it at that.
That is correct. So you see privacy and publicity rights, but let me explain to you how privacy and publicity rights sometimes also kind of pull into protecting companies and products, right? Let's take Shark Tank, for example.
Okay.
One of those 4 sharks decide that they're going to become an investor.
Okay.
And under the terms of the investment, they go out and they start selling this product. The dummies on the other side, the defendants, not only copy the product, not only, do what they do, they also take a picture of the shark and put it next to it, okay? So, because believe it or not, like I tell a lot of my clients, counterfeiting is the highest form of flattery. If people are...
Hi, I'm Jerry Parisi. Join Tom Mealy and Tommy Marr right here on Cablevision Channel 20 each week for an interesting episode of The Long Island View.